Welcome to Rebel Chaser. My name is Gail, and I've got a couple videos for you tonight. The first one is with Judge Hesselink, and this one's actually pretty funny because the guy's serious, and he thinks the judge is dumb. So, there's that. And then the second one is similar with Judge Mertz, and this woman tries to play a game with the court. Sometimes when you play the game, you end up winning. So, she won. And then there's two traffic matters that to kind of cleanse your palate, and the second traffic one is really funny. So, I'll let you guys watch.
All right, next case the court has is Jeff Hodges versus Andrew McHune. That's file 25-40756-GC. Set for a motion this afternoon. All right, if I could have the parties state their names for the record, please, starting with counsel.
Good afternoon, Your Honor. Matthew Kassar here on behalf of the defendant, Andrew McHune.
All right, and Mr. Hodges, you want to place your name on the record, please?
Hi, good afternoon, Your Honor. I'm Jeff Hodges.
All right. I have a motion from counsel for summary disposition, and I have a dismissal document from Mr. Hodges asking me to dismiss the case, and then I was handed today a form that's been mostly almost blacked out, so it's unintelligible from Mr. Hodges. So I'm going to ask Mr. Hodges first, what is this document that you sent to the court or dropped off at the court today?
This shows the criminal matter has occurred by Mr. Andrew McHune and the legal counsel for interfering attempts to interfere protected activities.
Mr. Hodges, this document doesn't show me anything. It's so blacked out. I don't know if you can, I know you can't read it from there, but it is without a doubt, there's about 6 words in total that I can read, none of which have any relevance to anything. I can read the words from, subject, date, to, FOIA, exempt, and then there's a federal court statute, 31 U.S.C. 323, but it doesn't tell me what case, when, where, how, or why. So this document is absolutely useless.
I cannot tell you the details because of the federal regulations and the confidentiality requirements. But because of this matter, I'm falling under the federal statute outlined in that particular paper. And any attempt to interfere that a protected activity is violating the criminal law. And the law is cited on the title, the confidential FOIA exempt, and the word after that.
The Freedom of Information Act has absolutely nothing to do with this case or a criminal case. There might be contempt or there might be some sanctions for violating a Freedom of Information Act request, but Freedom of Information Act is simply a discovery mechanism with absolutely no connection to this case that I can see at all.
It's because of the law, how it's designed. This whole matter is FOIA exempt. And attempt to interfere.
I don't understand what you just, sir, hang on a second. I don't have any idea what you just said. This whole case is under the FOIA? That makes no sense to me. Explain that.
Because of the activity I did under the word after FOIA exempt, the 31 USC 53, as you can see, the information, as you see now, has to be redacted because of the confidentiality requirements. And
are you claiming to be a whistleblower, sir?
You are correct.
How does that have anything to do with this case?
And the counsel has tried to use irrelevant material that is a part of the investigation against me, and either intentionally or unintentionally, that constitutes the witness intimidation.
Do you have a court order from the federal district court that says that we can't do anything in our case?
I don't know. This is way beyond a civil court.
Says who?
Well, this is a federal criminal matter, and I don't know why someone thought it's a good idea to get involved in this whole matter and keep going after me. And I think the action by Whitcomb and the CEO is very unwise.
Sir, I don't know that this is a federal criminal matter. You sent me a piece of paper that has on it the words FOIA exempt and a statute number. I don't have any idea that this even applies to you. I don't have this document shows me absolutely nothing. So there's nothing that this paper does or has or will have in this case. It's got nothing to do with this case as far as I can tell. I don't have an order from a court that says I can't do anything today.
The Exhibit A is violating the law cited in this paper.
I don't know what Exhibit A is.
That is your document presented by your the legal counsel of your defendants. Also, the defendants' activity invoke the violation under the law cited.
All right, Mr. Kasser, do you want to respond to that?
Your Honor, I guess several things. I haven't seen the document that Mr. Hodges provided to the court today, and I'm nearly positive it makes no difference. There's no criminal matter here that I'm aware of, not involving my client, Mr. McHune. Last week, I believe Wednesday, maybe Thursday, Your Honor's clerk gave me a call and said Mr. Hodges wanted to voluntarily dismiss this case. I spoke to my client and we said that's, we will consider that, but we would need to have the dismissal with prejudice so as to end this frivolous action. Mr. Hodges has not provided any contact information, so I wasn't able to contact him by today's hearing, so I figured we could potentially hash out the details of a dismissal today. Now, given these new, I'm not sure if they're allegations or into myself and my client, I'm not sure that my client is going to want to drop this motion, which seeks sanctions, seeks fee shifting for what we've had to do to dismiss the several cases that, by the way, Mr. Hodges has brought. Mr. McHune and previously Ms. Sheldon, who this court dismissed that case a couple weeks ago, did not bring any cases against Mr. Hodges, has not pursued any action against Mr. Hodges, terminated him for a reason, for valid performance-based reasons, and has since had to defend against frivolous actions filed by him. So that is all to say, we were open to exploring a voluntary dismissal from Mr. Hodges. I'm not sure if there's going to be additional retaliation and frivolous suits or criminal actions or anything like that. I'm not sure. I may have to talk to my client again about whether we want to continue to seek sanctions, because frankly, this is, I don't even understand what the allegations are at this point. And I'm happy to argue the motion for summary disposition today too, but I guess I'm not sure, Your Honor. I'm not sure where to go from here because I figured today would be, trying to hash out how the voluntary dismissal is going to go, not new allegations about criminal conduct on someone's behalf. I'm not sure whose. And FOIA, I don't think is relevant in any way, but I assume that the court is aware of that as well.
Yeah. All right. Mr. Hodges, your motion for dismissal is not granted. Right on the form that's used, and it's in the statute as well, it says under section 2C, no answer or motion has been served upon the plaintiff by the defendant as of the date of this notice. And that is absolutely wrong. Absolutely. It's, again, an example of you misusing the law. This was filed with the court July 14th, this request for dismissal, and we received from counsel the motion to dismiss at the end of June 26th. So I'm not granting your dismissal. Counsel, do you wish to argue your motion for dismissal, summary disposition?
Your Honor, if Mr. Hodges would like to discuss submitting collectively an order of dismissal with prejudice of this action, we are happy to do so. If that is not the case, because as you've mentioned, it needs to be by stipulated order at this point because there's a motion pending. If that's not the case, then yes, we're going to proceed with our motion for summary disposition. So not to kick the ball to Mr. Hodges, so to speak, but we need to understand whether he is going to agree to dismiss this case or not. And if not, we will proceed with arguing the motion and seeking sanctions.
All right, Mr. Hodges, do you wish to seek a conciliatory agreement to not prosecute? So the case will be dismissed without prejudice, or excuse me, with prejudice?
For this particular case, yes.
This is the only case that I'm aware of that is still pending.
Right.
Go ahead.
Let's use small words and say them quickly. He said yes. What do you want to do next?
Your Honor, I think because Mr. Hodges is reserving his right to file more frivolous actions, I think we need to go forward with the motion.
Fine with me. Please argue.
Okay. Your Honor, just briefly, I know you have the papers. This is a frivolous action filed by Mr. Hodges. It's initially filed as a small claims matter, and there was given a short paragraph, a couple paragraphs about how Mr. Hodges is seeking the expenses of his legal work to file this claim, which I think comes out to $60, $70. Because Mr. McHune, who is my client and who is the chief executive officer and president of Wade Trim Associates, Inc., has, quote, maliciously escalated a business dispute with Mr. Hodges. There is no evidence that has happened. Mr. McHune has defended himself in this case by filing a motion for summary disposition, and that's all. And even if there were anything, even if there was any cause of action actually pled, which there's not, there's no damages. There's Michigan, like all states, operates under the American rule. Fees don't shift unless there's a statutory exception or some other exception in case law, which there's not. So there's no damages in this case. There's no cause of action in this case. And Mr. Hodges' statement actually says itself that it is retaliatory and threatening against Wade Trim and Mr. McHune. And I quote, and I think I need to quote to understand or to put on the record how kind of incredulous this claim is. Mr. Hodges has pled that, and I quote, Andrew McHune and or his company are insignificant and irrelevant to me, to waste my time and valuable resources, and I hope this is a clear discouragement to any further illegal and adversary actions under Andrew McHune against me. I hope Andrew McHune will not mistake this as an encouragement for further retaliation and or adversary actions. Your Honor, this case is being brought to threaten, to harass, and has no merit whatsoever. And I do think that in this case, because of what is going on and because Mr. Hodges is now threatening more actions against either my client or Wade Trim or other employees of Wade Trim, I do think that sanctions are appropriate, despite the fact that we are well aware that sanctions are generally reserved for situations where people are represented by counsel, because there is some leniency. But as we cited in our briefs, that leniency is not, it's not absolute. And I think to disincentivize Mr. Hodges from further abusing the legal system, who he has now threatened myself too, with some sort of vague allegations of criminality, I think that sanctions in the form of fees for bringing this motion are warranted. And that's all, Your Honor.
Mr. Hodges, how do you wish to respond?
Well, after termination, in order to get me further into trouble, they have made a false police report accusing me with false allegations. And in this process, it has the attempt to interfere with the protected activities, that is a criminal matter at unrelated place. So because of this action by Wade Trim, also involving Andrew McHune himself, this constitutes criminal activity for everyone involved. And that's the reason I prefer to see this as de-escalation. And I have attempted requesting mediations again and again, trying not to escalate the situation further. And Wade Trim has deliberately refused our mediation attempts, causing escalation to this point. And I have to bring this out for my own defense. And they get into something they have no idea, and the consequences can be severe. And I hope it can be avoided.
Mr. Hodges, what police report are you referring to?
A police report was...
You've not filed any police reports with the court? No.
It's filed by Wade Trim. And this was included partially in the material submitted by the counsel of Wade Trim. By Kent County Sheriff Department.
Counsel, are you aware of what he's talking about?
Yes, Your Honor. There was a police report filed after. So I guess let me back up, Your Honor. Attached as Exhibit 2 is the affidavit to our motion is the affidavit of Andrew McHune. Attached there too are, I think, 60-something pages of very concerning, violent, threatening social media posts from Jeff Hodges that Wade Trim became aware of after his termination and felt the need to file a police report, which is, of course, its right to do. We're not sure where that has headed because obviously Wade Trim isn't conducting the role of the police. We just reported what we felt needed to report and move forward. Some of the reason that was reported was because there was a series of, which are highlighted in our briefs, Your Honor, a series of very threatening and violent statements that are made against employers and managers, and demonstrated a pattern from Mr. Hodges also, not only with the violent conduct, but his desire to use the legal system against his former employers. So that is the police report I believe he is referring to. That is not Wade Trim's determination of whether the police are going to continue to investigate, but it is relevant for purposes of this motion, which is seeking dismissal of these claims which have zero merit, and Mr. Hodges has not made any argument as to why this case should not be dismissed, but also why there should be sanctions to halt these frivolous filings and to kind of cut it off now. As again, we were willing to look into a voluntary dismissal. We would need to agree to what the language was for the dismissal. But now apparently Mr. Hodges has further plans to file actions, and that needs to be stopped, and this court can do so by entering an appropriate sanction.
Thank you. Mr. Hodges, your claim, when it was originally filed under the small claims matter before it was moved to the district court, said that Mr. McHune maliciously escalated a business dispute under his instruction through some series of attempts to retaliate, harass, intimidate, or stalk you. Tell me how that occurred.
The general counsel, the description he has about the online post, many of them dated exactly around the same time frame as this paper, September 13, 2024. They are protected activity, and any attempt to use it against me is a criminal conduct. So please don't do that.
Mr. Hodges, what you're alleging is action taken by counsel after you filed your small claims matter. That you can't do something that happened after that to prove something that's supposed to be already in evidence. I'm asking for what evidence at the time that you filed your small claims case shows that Mr. McHune maliciously escalated a business dispute under his instruction.
By filing the police report, and
That's
there were
afterwards,
few
sir.
employees.
Sir, that's after you filed this matter. He responded in the way that he did. I'm asking you, what did he do before that you're complaining about originally?
This particular case was filed in May this year, and the police report was filed in late April this year.
So how is that in any way connected to the firing of you from Activent Incorporated when Mr. McHune works for is the owner of Wade Trim?
Because in my LinkedIn history, there were few employees seeing my profile, and that's their time. They were using that information against me by filing a false police report in late April 2025.
So what is your proof that it's a false police report?
The false police report is included in your hands, and your local prosecutor.
What proves that it's false? What proves that it's false?
Because the accusation is untrue, and they are misused against me, and
saying
that's
that
their
it's
protected
untrue and
activity.
it's false doesn't make it so. What's your proof that it's false or untrue?
The content is misused and irrelevant. Thus, it's an abusing the privilege to file a police report against me.
What is untrue about it? They just printed out what you wrote.
The action of the police report is frivolous. That's the point I have.
Say that again, because I didn't understand what you said.
It's the frivolous action by a Wade Trim to file a police report like that. And
what is the word that you
attempt?
No, the word that you're using before action? I don't understand what you're saying. It says I can't pronounce what you just said.
It's meritless for them to file a police meritless to file a police report, and it's a misuse of their position.
Why is that? Because you don't like it?
It's because it's an attempt of interference of their protected activity.
So you file an action against the boss of Wade Trim because you got fired from the company that is a temp service for you to work at Wade Trim, and now you're mad at them for getting out your posts on the public access social media. And again, I still see absolutely no connection between those things. Why is it wrong for them to find out what you posted?
Because those posting was a part of your larger protected activity to go after other companies.
Protected activity for what?
The whistleblower activity itself.
You're not whistleblowing. You're spouting off some political rhetoric.
Yes, which is
that's not whistleblowing. And there's what case were you involved in at that time that you were whistleblowing on? Who did you whistleblow to? What protection did you receive from that agency?
You can probably subpoena that person, Neil, and I can provide the full name.
I'm not subpoenaing anybody. I'm not an investigator. This is a court. Where's your proof of any of those things? You come in here telling me that you're a whistleblower. I've got absolutely no proof of it. I see some social media posts of a man who's upset and is telling people how to do certain things if they don't want to get fired. You get fired, and now you're mad at them posting, having access to the very things that you posted about. What has that got to do with anything in this case?
That's when I was trying to talk to some of the employees of certain companies to get them to talk. So I can verify the information from within with the public information to verify the misconduct of certain organizations doing certain business, violating certain federal laws. And I submit such information to the particular federal agent that was cited, redacted in that particular email, creating the TCR. And I have redacted the full number of the TCR, but you can see the first 2 digits out of that, which is 14. There are around half a dozen TCRs being associated, and they are still actively working with me to continue the investigation to hold those companies accountable.
Mr. Hodges, you strike me as a conspiracy theorist of the worst type. You went into this, it appears to me, from reading all of your statements in here, you went into this whole deal trying to figure out a way to sue this company, and you're not even suing the company that hired you. You're suing a different company that was engaged, had a place of business, and you got sent there by the company that hired you. You got fired for being a bad employee, and now you're whining about it because your social media posts caught up with you. This is the definition of a frivolous lawsuit. The quote made by counsel is very telling. Even in your initial pleadings, you were telling them that you're retaliating and that you're doing things to set them up for harassment things. This is the worst misuse of the court system that I've seen in a long time. Your dismissal paperwork shows me that you're not filing things in good faith. I was the judge in your previous case against one of the other employees of Wade Trim. I dismissed that matter, and quite frankly, I was surprised that they didn't ask for costs and sanctions in that matter. So counsel, I'm granting your motion for summary disposition, and I'm granting your request for costs. Did you submit a proposed judgment to me or not?
No, Your Honor, we will do so, and we will also submit a breakdown of the costs and fees for Your Honor's consideration.
Thank you very much. That's all for today then.
Thanks, Your Honor.
Okay, we'll go on the record in People versus Mallory Stefan. This is Crawford County case number 245348. If I could have counsel put your appearances on.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Richard Trush appearing on behalf of Ms. Stefan.
All right, and record should reflect Ms. Stefan is present there in the courtroom in Crawford County. I'm connected by Zoom, as is Ms. Koch. Mr. Trush is live with his client at the courtroom in Crawford County. Mr. Trush, my understanding is that Ms. Stefan wishes to enter a no contest plea today. Is that correct?
I do believe that that is what we are going to do today.
Okay, can you tell me what the terms of that agreement are?
So the terms of the agreement would be that count 1, the assaulting a corrections officer charge, would be dismissed. Count 2 would be amended from resisting and obstructing a police officer to attempted resisting and obstructing a police officer, reducing it from a 2-year offense to a 1-year offense. Count 3 would stay as charged, and count 4, the escape from lawful custody, would be dismissed.
Ms. Koch, is that a correct statement of the plea offer?
It is.
Ms. Stefan, can you hear me okay?
Yes.
Have you had an opportunity to talk to Mr. Trush about this plea agreement? Have you had a chance to talk to your lawyer about this plea agreement, Ms. Stefan?
Sort of.
Do you need more time to do that, or are you ready to proceed today?
Can I have more time to do that?
How much time do you need? Hello?
I'm not sure.
Well, Ms. Stefan, I know this is kind of a pattern with you. You like to do this and indicate that you're going to go forward with something and then say you're not sure and you don't know. So I'm not going to play games with you here today. I'm not going to waste my time. I'm a busy person. So if you want to enter into this plea today, we'll do it. If not, we're going to go forward with your trial on Thursday. So you need to decide that right now. What do you want to do?
I don't know.
That's not an answer. You either need to say you'd like to proceed with your trial, or you need to say you want to enter into a plea today. I don't know is not an acceptable answer.
Your Honor, can we have 5 minutes to talk?
Yes. We'll go off the record, and Ms. Koch, if you could just remain on the line, please. Thank you.
I will. And for the record, the plea offer will be revoked after today's hearing. It was made in September. It's been pending for 9 months. Thank you.
Well, I want you to say that again when Ms. Stefan is there. I don't know if she heard that, so.
Okay, thank you.
Okay, Ms. Koch, if you can rejoin us, please.
I'm here. Thank you.
Okay, Mr. Trush, how are we going to proceed?
Your Honor, I believe she intends to take that offer, but again, I'll ask the court to directly inquire of her.
Okay, Ms. Stefan, are you going to proceed with the plea today?
Yes.
Can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You can lower your hand. Ms. Stefan, are you currently on any kind of probation or parole?
No.
You understand that by pleading no contest to attempted resisting or obstructing a police officer, the maximum penalty you could face would be up to 1 year in jail. Do you understand that?
No.
What don't you understand about that?
Can you repeat that?
Yes, the maximum possible penalty for the charge of resisting or obstructing as an attempt is up to 1 year in jail. You understand that?
Yes.
The maximum possible penalty that you can face for domestic violence as a second offense is also up to 1 year in jail. Do you understand that?
Yes.
With those maximum possible penalties in mind, what is your plea today? Are you pleading no contest to those two charges today?
Does that mean I'm pleading guilty?
Well, my understanding is the plea agreement is that you're going to plead no contest.
So Mallory, we discussed the difference between a guilty plea and a no contest plea. In a no contest plea, the judge would review the police report to form a factual basis. In a guilty plea, you would tell the judge under oath what occurred on that night that would make you think you were guilty of the offense. You understand the difference?
Yes.
So the judge is asking,
Yeah, go ahead, Mr. Church.
are you pleading no contest to the charge today?
Okay.
Okay is not an answer. Yes or no?
Yes.
I'm sorry, what's that? Yes or no, Ms. Stefan?
I said yes, it's fine.
All right, I'm going to go through your rights with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and the right to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all those rights?
Okay.
Again, that's not an answer. Do you understand them or not?
Most of them.
Which ones don't you understand?
Can you repeat the last couple of them, please?
I'll repeat them all for you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it.
I want a trial.
So you're not going to plead no contest today?
Is the no contest the same as pleading guilty? Or is it just
No,
taking the plea?
It's not the same, and your attorney just explained to you what the difference is.
Okay.
So are you going to move forward with this plea today or not? Ms. Stefan, are you going to go forward with this plea today or not? Yes or no? I don't care which it is. Doesn't matter to me. I just need some answers from you. That's all. One way or the other. We have a trial scheduled and ready to go on Thursday if you want to have your trial.
I'm just confused, that's all.
Okay, so I don't believe you when you say you're confused. You've had many, many months and numerous court hearings where all of this has been explained to you. I know that Mr. Trush has fully explained everything to you today as well. So I just don't believe that you're confused or you don't know what's going on. You need to make a decision now. And again, I don't care. We have your trial date all set. We're all ready to go on Thursday. More than happy to do that. But if you're going to enter a plea today, then that needs to happen right now.
Okay, fine, yes.
Okay. Do you understand all those rights that I've listed to you?
Yep.
And you understand that you're giving up and waiving all of those rights by pleading no contest. You understand that?
I can't be in here.
Do you understand that you're giving up all those rights by pleading no contest?
Yes.
Has anybody threatened you with anything to get you to plead no contest? Has anybody threatened you with anything to get you to plead no contest? I'm going to ask one more time, Mrs. Stefan, and then that's it. I'm going to end this hearing and we'll proceed on Thursday. Has anybody threatened you with anything to get you to plead no contest?
No.
Has anyone promised you anything other than what we've said here in court today?
No.
Is it your own free choice to enter this plea? Is it your own free choice to enter this plea?
Okay.
Yes, it is. Or no, it's not. Ms. Stefan, is it your own free choice to enter this plea today? Yes or no? Okay, I'm going to ask you one final time. Is it your own free choice to enter this plea? Yes or no?
Okay.
Again, okay is not an answer. Yes or no? Yes or no, Ms. Stefan?
I guess so, yeah.
Sarah, did she say I guess so, yes?
She said, I guess so, yeah.
All right, okay.
Not yes, but guess so, yeah.
All right. Mr. Trush, have you reviewed the Crawford County Sheriff's Department report number 2412001073.
I have, Your Honor, and I went over that with Ms. Stefan before the hearing today.
All right, and Mr. Trush, would you agree that that police report and the information contained within that, specifically pages 3 of 4, well, actually, yeah, 3 of 4 and 4 of 4, that the information would provide a factual basis for finding of guilt as to the count 3 and the added count 5 of attempted resisting obstruction?
Yeah, Your Honor, Ms. Stefan has,
I know, I need time to think about that, so.
Ms. Stefan has just indicated to me she does not want to take this plea deal.
Okay. All right. So, Ms. Stefan, we're going to proceed with your trial on Thursday. You need to be present in the courtroom by 8:30 on Thursday morning. You need to communicate with your lawyer between now and then so that Mr. Trush can be fully prepared to go forward with your case. I think we probably already covered this at a prior hearing, but Ms. Koch, you have already submitted jury instructions, is that correct?
That is correct. We are prepared. We have all of our witnesses served and ready to go. People are ready to proceed. Thank you.
All right, and Mr. Trush, have you submitted any of your proposed instructions or any objections to the prosecutors?
I believe that we did submit, I think we submitted them prior to the prior trial date, which I think got adjourned. I would indicate I have prepared a self-defense instruction. I didn't submit it because I don't know if it will become relevant or not, and it likely will turn on if Ms. Stefan testifies and what that testimony looks like. But I prepared multiple copies of it in case it does become relevant.
Okay, all right, very good. And just for the record, because I don't know if we caught it before, but Ms. Koch, you're withdrawing the plea offer, is that correct?
I am withdrawing the plea offer today. We will proceed to trial on all of the felony charges. Thank you.
Okay, so Ms. Stefan, this is your last chance. Once we go off the record here, there will be no more plea agreements. Even if the prosecutor offered it, I wouldn't accept it after this. So, is that your decision?
Okay. Can you repeat the question, please?
Just asking for a final decision from you as to whether you want to go to trial or whether you want to accept this offer today. This is going to be your last opportunity.
Okay.
I don't know what okay means. Do you want to go through with the plea or not?
I really need a few
Yes
minutes.
or no? No more minutes. You've had months and months and months to make a decision on this. Another 5 minutes isn't going to change anything.
Okay, let's.
I couldn't hear you. What?
Yes.
Yes, what? You want to go forward with the plea or you want to go to trial?
All right, it's fine.
When you say it's fine, do you mean that you want to proceed with the plea or you want to proceed with the trial?
I'll keep going with it today.
Do you want to enter into this plea agreement? Yes or no?
Yeah, yes.
All right. So again, I think we were going through the factual basis, Mr. Trush. Would you agree that the information I've identified would provide a factual basis?
I do, Your Honor.
Ms. Koch, have you reviewed that police report that I've identified for the record?
Yes.
Would you agree that it provides a factual basis? Charges?
I don't get to tell my side.
I'm sorry, Your Honor, I didn't hear that question.
That was directed at Ms. Koch. I'm just establishing whether she's satisfied with the factual basis based on the information contained in the report.
Yes, Your Honor.
Ms. Koch, are the people aware of any threats, promises, or inducements other than what's been placed on the record today?
No, Your Honor.
Mr. Trush?
No, Your Honor.
Ms. Koch, are the people satisfied that the court has complied with statute and court rule in the taking of this no contest plea?
Yes, Your Honor.
Mr. Trush?
Yes, Your Honor.
Ms. Stefan, the court finds that your plea is knowing and voluntary. I'm going to mark that police report that I've identified as Court Exhibit 1 and admit that to the file as the factual basis. I've reviewed the information. I find that it does provide a factual basis to support a finding that you are guilty of each of these charges. The court will accept the no contest plea. The court will set this matter for a sentencing hearing in about 30 days. In the meantime, Ms. Stefan, you're going to meet with Mr. McFalda, I believe, today before you leave the courtroom to set up a time for a pre-sentence report. Then it's important that you stay in touch with your attorney prior to that sentencing date. You'll have an opportunity to go through the pre-sentence report with him. In light of the plea, the court will adjourn the trial set for Thursday. Ms. Koch, anything further from your side today?
No, Your Honor. We will call off our witnesses for the trial. Thank you.
Mr. Trush?
What is that?
Never mind, go on.
Nothing further, Your Honor.
Okay, thank you. That's all for this hearing. Okay, all sides are free to disconnect at this time. We're on the record in People versus Mallory Stefan. Stefan, if you want to come up to the podium here, please. This is file number 245348. The record should reflect Ms. Stefan's present here in the courtroom today. This is the date and time set for sentencing in this matter. If I could have counsel put your minutes on.
Sierra Coke on behalf of the people.
Your Honor, Richard Trush, on behalf of Ms. Stefan.
Ms. Stefan, have you had a chance to go through the pre-sentence report and talk to Mr. Trush about that?
I didn't know. I don't think I got one. On paper?
Mr. Trush, did you go through the report with her?
We went over the recommendations. I didn't provide her a hard copy of the report.
Okay. Did you want to review that report before we get started?
Okay.
Okay.
I would actually like to withdraw my plea, take the trial.
Okay. What's the basis for withdrawing your plea?
That was originally the plan that I had wanted to do in the first place, was take it to trial.
You changed your mind, is that?
I didn't really change my mind. That was the first one I was making a lot of court date too.
Okay.
I just didn't really think it was so I didn't really think you guys said.
Well, we had a really long hearing there.
Yeah.
So there's only a couple of reasons why you're allowed to withdraw your plea after the court accepts it.
Okay.
Number one, if there's an error in the plea taking process, in other words, if I forgot to do something that I was supposed to do, advise you of some rights that I was supposed to advise you of, if you didn't understand what was going on at the time. I'm confident that you understood exactly what was happening on that day.
Not really.
I know that's what you say, but to any rational person.
Okay, but I'm not the only one guilty in this situation. So that's why I want to take the trial.
Okay, I'm explaining to you why you're not going to do that. Because there was no error in the plea taking process, in my view. there's no reason for me to allow you to withdraw. So.
Well, I said that at that time, the last court hearing, because that's not what I wanted. I told you that at the time.
Yeah, I hear you. I'm not gonna allow you to withdraw your plea because in my view, you knowingly and voluntarily entered into that plea on that day. So we're gonna go forward with sentencing today. Would you like a chance to read that report before we do that? Yes or no? Okay. So you want to take a second to get a copy of it? Provide this. So, yeah. Yes. Now, did you have a clean copy of paper copy that you get?
I do, Judge.
Mr. Church will give her a paper copy. So, Mr. Van, if you want to have a seat in the courtroom there, you can. Here's the report. Just to review that. Mr. Van, if you want to come back up to the podium, please. All right, so the record should reflect Mrs. Stefan was given a paper copy of her BSI. She's had an opportunity to review that while we took care of some other matters.
Accepted that answer. Unless I said that I wanted to take a reader, not necessarily. I said I wanted to take a trial method, and you guys accepted that answer.
So we're done. We're done with that. I'm not talking to you anymore about going to trial.
Okay, but none of this. Some of this stuff is not true. Some of this stuff is not true.
Okay, you're gonna have a chance to tell me what's not true and what is true.
You have it on here if it's true. You say that I fled the building. I left because you guys wouldn't accept my answer that I wanted to take the trial. I told you I wanted to take the trial and you wouldn't accept that answer.
In about 3 minutes, you're gonna have a chance to tell me everything you want to tell me. Okay.
That doesn't change this though. That you wouldn't accept the answer that I said I wanted to take a trial, but you would accept that the plea deal, because that's the answer that you wanted me to do. I didn't want to make that choice. I stood right here and told you guys both that I wanted to take it to trial, and that answer wasn't acceptable.
Okay,
so why wasn't that answer acceptable?
I need to conduct this hearing. If you're going to keep interrupting me, then we're going to stop the hearing and have you taken into custody. We're going to try again at a different day.
Okay, because
I'm not going to keep listening to what you're saying because it's not correct. We had the hearing.
That is correct. I stood right here and told you that I wanted to take it to trial, and you wouldn't accept that answer. You guys went ahead and pushed for the plea deal anyway.
We're going to revoke Ms. Stefan's bond. We're going to take you into custody at this time. You're going to be held without bond. I'm going to reset this for a sentencing hearing at a later date.
So what?
And you'll get jail credit towards your sentence for the time it's being held now.
Because you don't want to hear the truth about what happened. She said that I saw her, that I kicked and hit her, and I didn't. My cousin had to show up and spray us out of the house.
Because you keep interrupting me. Because you keep interrupting me, and I can't conduct this hearing.
Because you're not listening.
So for the record, my court will reset this for a sentencing hearing at a later date, and I'll notify counsel.
Here.
I'll also issue a written order revoking her bond and remanding her to the jail pending that sentence.
Mr. Hake, if you would turn on, there you go. This is 25 IRO 02257. This citation was issued for disregarding a traffic control device on the 15th of April, about 5 after 9 in the morning, 11 mile near Troy Street. You can admit or deny responsibility, or you can admit responsibility with an explanation. How do you wish to proceed? Mr. Hake, can you hear us?
Yes. Hi. Good morning. How are you, sir? Yes.
I asked you a question, sir. Are you admitting or denying responsibility?
Yes, I'm here.
I know you're here. Are you admitting or denying responsibility for the infraction?
No, I'm admitting.
No, you're admitting. Did you set up the hearing to make an explanation?
I am a Uber driver. So I have a passenger.
You had
But,
3 passengers.
Yeah, I have a passenger. Yeah, 3 passenger, right? So police stopped me, but I don't know why he stopped me. And I
They
asked
stopped you because it's alleged you ran a red light.
No, I never with this red light. You see the ticket? He riding the yellow light. Yellow light, but I don't know the yellow light. They pass the light, then yellow. I never beat the red light. Never. Just this is not true. It's not true.
That's a
And
denial.
No. My passenger said this is the.
Okay, I don't care what your passenger said. That's hearsay. If they're not here to testify, you can't tell me what they said. But I'm going to change what you first said. You said that you admitted responsibility, but then you said you didn't do it, so that's a denial. Now I'm going to ask you to raise your right hands, please.
Okay.
Do you swear or affirm that the testimony you're about to, are you going to raise your right hand or not? Raise your right hand to take the oath or affirmation. Do you swear or affirm that the testimony you're about to give will be the truth?
True.
Your Honor.
The officer will testify first, please.
Your Honor, on the listed date and time, I was in the area of 11 Mile and Troy Street. I was working a TIA distracted detail, and I observed the listed vehicle go through this red light at westbound 11 Mile and Troy. I initiated a traffic stop on Main Street, just northbound Main, just south of University, made contact with the driver, who did say that he was an Uber driver and did have 3 Uber passengers in the car, and made contact with them, issued a citation accordingly. Your Honor, this infraction was captured on my dash cam, but I don't believe it's still there due because of the date and time of when I issued the citation. I don't think it's still available for the court to see if it needed to be.
Yeah, the defendant failed to appear in court last month when the hearing was originally scheduled, and then they rescheduled this for him. Okay. It's your turn to testify, Mr. Hack. Mr. Hack, it's your turn.
Yes, sir. What's the question?
What do you wish to testify to? It's your turn to tell your side of the story.
Okay.
Mr. Heck, what happened on April 15th?
Yes, Your Honor. I'm telling you this. I'm not.
What are you telling me? I haven't heard anything yet.
Oh no! I not beat the red light. No, it's not true. I don't know why officer give me this summon. I don't know. This maybe why.
You're under oath, sir, and we're not going to have a testimony as to maybe. You've testified you didn't run the light, that it was not true. Is there anything else you want to say?
No, nothing. Just, but I'm sure I'm not beat the red light. I'm positive, but I don't have evidence. I have a camera, but this time the camera off. That's the bad luck for me.
Your Honor?
Yes, sir.
I am looking at myevidence.com. It's still available if the court would like to see it.
Do you want to show it?
Yes, if it's okay with you, Your Honor.
Sure. If you want to.
All right, can you see my screen?
Yes. Can you make it a little bigger? No, perfect.
This is the listed vehicle right here, Your Honor. Traffic light is red right there. He goes right through it.
Can you back that up just a little bit?
Want to see it again?
No, not for me. I saw it. It's.
It
Mr.
turns
Hake,
yellow, then it turns red, and then he goes right through it.
No, I passed already. Then you said right is right.
it was red when you went under it.
No, I already passed. You see, my car is where and where is the light? I already passed. Then after the red light.
No, that's one of the reasons why I've always questioned the need to show the tape, because even if you see it, you don't believe it. The officer gave you a break because he didn't cite you for driving through a traffic control device. He cited you for a traffic control, or he didn't cite you for a signal, he sent you for a device. And that saved you some money and a point. The fine is $130. There's no ambiguity. It shows what it shows.
Okay.
It can be paid online or by mail, or you can drop by the courthouse and pay the $130 at the counter. But it does need to be paid soon.
Okay. I can pay. I can pay what the.
Sorry about that, Your Honor. I didn't know if you wanted to see it or not, but
No, that's totally up to you. I think it's a question of, if we're looking at it to convince the defendant, he's not going to be convinced. It's.
I thought it was also helpful due to him having a language barrier too. So I mean,
Yeah, sure. The language barrier doesn't change the color of the light. We have Ms. Waters and we have Ms. Spangler, and this is 25P139786, people of the city of Royal Oak versus Selena Lee Waters. Ms. Waters, you've been cited for a parking violation of parking head in on Washington with a parking where that is prohibited. All the parking has to be backing into those spaces. Are you here to admit or to deny responsibility, or to admit with an explanation?
Deny.
Okay, raise your right hand.
For the record, I'm not.
For the record, please raise your right hand.
Mm-hmm.
You swear or affirm that the testimony you're about to give in this matter will be the truth?
I affirm.
Yes.
Okay. And the officer will testify first, please.
This violation occurred on May the 23rd at about 11 minutes after noon. It was at 608 South Washington. That is an area that is heavily marked as being back in only, and the vehicle was parked facing forward in. There are various ways to see that. Some are on the pictures. There's signs in the middle of the road. There's signs on the side of the road on taller posts. There's notification on the back of every bollard and meter. And when somebody does go to pay at the meter, the first screen also reminds people that they must be backed in. So this vehicle was not backed in, which is why I issued a ticket.
Thank you. Ms. Waters?
I am here as authorized representative for the trust. So I'd like for that to be noted. It's not Ms. Waters, it's for the trust. And I sent you the document which states.
Your name is Ms. Waters.
I am the trustee.
We're here as the trustee of your trust.
Correct. I want that on record. And if we're going to proceed, and she has pictures.
We are going to proceed.
I
Please
need
go ahead. Ma'am?
If we are proceeding, I need discovery. If she has pictures, I need discovery. I need the same thing that she has.
You were there to see it all, ma'am.
Who?
You were there to see it.
There are pictures of me there?
Are you denying that you were there?
I've already denied for the
responsibility
record,
for the civil infraction. Are you denying being there?
And I am asking for discovery, as is my right under anything, including a parking violation. Am I correct?
No, you are not correct.
I'm not due discovery on a parking violation?
You haven't properly filed for discovery.
My documents are on the record. You had them the very last time.
And the records are not reflective of reality that you've provided. A statement saying that you're entitled to a contract, and then you cite a statute that deals with the statute of frauds.
The motion for specific discovery is on the record, is it not?
I don't know that if you'd say it's on the record. It is in the file. You said that you served it personally by mail and by fax, I believe, that one of those three did get through. I have seen your motion. I have read your motion, and I have denied your motion. You can proceed.
I need discovery. If she has pictures and anything else, then I need to see that as well, as is my right. Also, St.
It is
Clair
not your right.
Matthews, you cannot ticket a trust. And that is clearly
That's not true either, man. The
Mm.
car was ticketed. The trust owns the car. You say.
It is trust property, meaning the trust has been ticketed.
The car was ticketed.
The car
The trust owns the car. The owner of the car is responsible for parking tickets.
Which is the
that
trust.
are received.
I do not own that vehicle.
The trust does.
Exactly. So
What's
this
your
is
point?
why I'm asking for discovery. If
No.
there are pictures.
Ma'am, the testimony is clear. There are signs in the middle of the street directing back in parking only. The officer testified. She testified that the requirement to back in only is on the screen that's on the meter. She testified that it's on the sign prohibiting head-in parking is also on the poles that the meters are on.
I did hear that.
And any vertical surface has it.
I was not driving.
If you want to contest
I did
that, you
not
can go
park
look.
the vehicle. So this is why I'm asking for discovery.
This is, ma'am, it's irrelevant.
When is discovery ever irrelevant if she has something I don't have?
But it's not as to a material fact. And if you wanted to dispute the fact that are you disputing the fact that there's signage?
No, I'm disputing the fact that I don't have all of the same information that she claims that she has. So that
Let's talk about what you need. Are you disputing the fact that there is signage on Washington requiring back-in parking?
I wouldn't know because I haven't seen it. So I need to see the pictures.
Well, then you're not prepared for today. It's the finding of the court that you're responsible. The officer's testimony is uncontroverted. The fine is $50. You can pay it online or by mail, or you can drop by the courthouse and pay it. We are done.
What's your P number?
Figure it out.
I'll figure it out.
Oh.
My P number is 29798.
2979 what? H as in happy?
No, 8 as in between 7 and 9.
Thank you very much.
Okay, so the first guy, I don't know who sued who. I have a feeling the company sued him to stop him from posting defamatory information or defamatory comments about the company that he was working for. He got fired because he was a crappy employee. I mean, would you want that guy working for you? If you had a company, would you want him working for you? I certainly wouldn't. So what he does is he turns around then after he gets sued and says, well, I'm a whistleblower. You can't do that to me. Well, actually you can, because posting stuff online is protected, but defaming a company or a person online is not protected. So you cannot do that. And I think that's what he did. I'm really not sure because I didn't get to see the posts, but maybe I should look him up, Jeff Hodges on LinkedIn and see what he wrote. But anyway, yeah, he thinks he's a whistleblower because he got fired because he's a bad employee. That's really it. He thinks now he's a whistleblower. And then the one with Judge Mertz, the reason I put in the previous hearing, that hearing was done in June, where she pled. And that plea has been on the table since last September. She could not make up her mind. She couldn't say, yes, I want to go to trial. Yes, I want to take the plea. She went back and forth, back and forth, back and forth. He pressured her to make a decision. He didn't pressure her on which decision to make. In fact, he clearly said, I don't care which one you choose. We're ready to go to trial. Just choose one. And she had the hardest time doing that. So sometimes when you play a game with a judge, you end up winning handcuffs. That's what she got. Now the plea has been withdrawn. So now she doesn't get 2 misdemeanors. She gets felonies. So, and then the traffic ones, the first guy, there was a language barrier, but he clearly went through the light. And just like the judge said, you can show them and they'll still say they didn't do it. And then the last woman, she was a sovereign. They just spew the same nonsense. So anyway, thank you guys so much for watching, and I'll see you another time.